All right, let's go back on the record in Cineworld.
Did you have a chance to figure out what time you need?
Ashley Harper for the record, Your Honor. Yes, so the break, I appreciate the break. It was helpful. I have the answer now. Do not need a further break.
Great.
So I had an opportunity to talk to co-counsel about Your Honor's solution, which would have made sense, but for co-counsel reminding me that we have independent causes of action and claims against the landlord as the owner of the escalator that we're not willing to waive at this time and want to proceed with those. Additionally, there's an additional fact about the status of the proceeding in the Western District of Texas case, and that is that on January 31st, Schindler filed a motion with that court seeking to stay the entire proceeding. So we would be in a situation where we have Schindler seeking to stay us from moving forward in the underlying action as well.
So I mean, I'd read what Schindler filed, but I think that if I were to issue the ruling I was talking about, that probably wasn't. We could make it subject to your being able to move ahead. But if you want to bring your independent cause of action against the landlord, I'm in no way going to try and take that away from you. That just means I'm going to let the debtors proceed with their motion today. So let's proceed.
Thank you.
Thank you, Your Honor.
Oh, hold on, I've got somebody else to see. Yes, from the 917 area code, who do we have? Thank you. And what evidence do you wish to introduce today? All right. Does anyone wish to oppose the debtor's motion?
Yes, Your Honor. Ashley Harper for the Aguilars. We oppose the relief requested. I mean, as the legal standard requires, the debtors bear the burden to put on evidence of the unusual circumstances that warrant extending the stay to a non-debtor. Here we have, in the underlying action, a non-debtor landlord. It's not an officer-director situation. It's not an affiliate situation. This is what we have here is a landlord. There's an order by the district court judge that once the suggestion of bankruptcy was filed, the next day the court issued an order, the district court issued an order that said that the action was stayed as to the debtor but may proceed against the landlord. And you know, that is what we've been operating under. There is no evidentiary record today before you. There is argument that the indemnification that would ultimately come back to the debtor if we were to prevail against the landlord is what the debtors are saying should, you know, stay the proceedings, stop the deposition from going forward of the landlord's corporate rep on Thursday. We are following decisions from this court regarding the stay, and we certainly respect the automatic stay and certainly don't want to be in violation of the stay or have any issues there. We need some guidance from the court on this issue that we're here on today so that we can be, in good stead with this court and the district court as we go forward. What you've heard today is that by the debtor's own admission in their pleading, that Schindler has accepted the debtor defendant's tender of the claim. They've undertaken the defense of that claim. So if the depot were to go forward this Thursday, a debtor representative would not need to be present. Presumably it would be the landlord's 30B6 rep that would be sitting for the deposition. It would be counsel to Schindler there as well. So the emergency nature, and why we're here today, I mean, there's an emergency in the sense that there's a depot Thursday, but there's not any harm that would befall the debtors if there were to go forward. So I don't think that the debtors have shown you that there's unusual circumstances here to stay the depot and certainly not to stay the entire litigation. So as Your Honor had raised at the start of the hearing, there's also the issue of this indemnification that flows the other way that then we don't know standing here today whether or not that would then take care of any indemnification that the debtors owe to the landlord. We also, the debtors make no mention of the fact that in our underlying cause of action, we've alleged negligence, which would be an exception to the indemnification provision that exists in the lease between the landlord and the debtor. So there's also no mention of potential insurance coverage, thus leaving the estates untouched. There's no mention of the fact that if there is an indemnification claim, it would be just another unsecured claim. So, Your Honor, based on the record you have before you today, which doesn't include any evidence, and it includes just argument from the parties, for the Aguilar's position is that the debtors have not met their burden to show the unusual circumstances that would exist to extend the stay to the non-debtors in the underlying cause of action, and we respectfully request that you deny the debtor's motion.
Thank you. Anyone else wish to make an argument? Or Ms. Levine, do you have a response?
All right. I'm denying emergency relief today. I don't understand why anyone would proceed with a hearing of this nature without any evidence. This is evidentiarily based. I have pleadings of a claim that would seem to be insured and zero evidence about what the insurance policy says, nor do I have the insurance policy offered into the record. I have stated in the motion that the debtor may be fully indemnified for this loss by Schindler. I don't have a copy of that indemnity. But if the debtor's fully indemnified by Schindler, I wouldn't grant emergency relief. All that we're talking about here is a deposition in terms of what the emergency relief is. This is a zero record, a minor type of emergency, i.e. that there's going to be a deposition for which based on the admissions I've got, the debtors may be indemnified for all the costs of the deposition. I don't know. But the debtors can't come forward without any evidence and expect me to extend the stay to something that it doesn't automatically extend to. Emergency relief is denied. I'm going to instruct the clerk to set the motion for a regular hearing after the expiration of 21 days, and we'll see if there's going to be a non-emergency basis and an evidentiary record to do anything about this. But I'm not going to do it with no evidence on an emergency basis. So emergency relief is denied without prejudice to what might happen in the long run. Thank you.
Thank you, Your Honor.